am I entitled to return to work if I've been away with an illness? The short answer is yes. If you have remained employed, even if you've had time off, you're entitled to return to your job. As we touched on before, the key question your employer will be concerned with is whether you still have capacity to safely perform the inherent requirements of your job. In this case, your employer may request medical evidence from your treating practitioners that confirms and supports that you do have capacity to work in your previous role safely. If you are able to return to your previous duties to an extent but require some changes to accommodate you, you have a right to request your employer make reasonable adjustments to accommodate your return to work. So, what are reasonable adjustments? Olivia touched on them in some great detail. I'm going to expand on that a little bit from a legal perspective. As we went through, they're really any changes to the work environment or your conditions that allow people with a disability, such as cancer, to return to work safely and productively. For example, a reasonable adjustment that we commonly see is making modifications to a workstation, which might be a different chair, a standing desk, a larger monitor to help you see better. Something like I've seen a lot of people need to be closer to the bathroom and have their desk moved to a position that's a bit closer to the restrooms. That's another reasonable adjustment. It might also be things like taking more breaks or longer breaks throughout the period of your workday. The reasonableness of the requested adjustment requires a consideration of how effective the adjustment will be in helping the worker, how practical it is to make that adjustment, including any disruptions it may cause to the organisation at large, and the financial costs of the adjustment, which includes whether the employer has capacity to meet the costs for making the adjustments. Reasonable adjustments can also include things like flexible working arrangements. Employees have a right to request flexible working arrangements under the National Employment Standards if they have a disability. Flexible working arrangements may include working part-time, starting and finishing at different hours, working shorter hours or less days, or working from home. Again, where these requests are reasonable in the circumstances, your employer is required to make these adjustments and provide flexible work arrangements for you. Next, what if on my return to work, my employer changes my role without my consent? The general rule is that your employer cannot just unilaterally change your role. In order to do so, your employer would need your consent and agreement to the new role, which would usually mean that you would be provided with a new employment contract that sets out your new role and duties in some detail, and you would be required to sign and agree to that. In essence, this would amount to a termination of your old employment, which could give rise to an unfair dismissal or adverse action claim if this new role placed you in a worse position than you were in before, or if the reason for the decision was discriminatory. For example, if you thought they were putting you in a worse position or making you sign a new contract because of your cancer diagnosis. Or if because they don't want to make reasonable adjustments for you and they're annoyed that they've had to do that. So that brings me to the next point. What if I am discriminated against at work because I have cancer? As I've said previously, cancer is considered a disability, and discriminating against someone because of their disability is illegal under the Disability Discrimination Act 1992. Disability is also considered a protected attribute under the Fair Work Act. So you're protected from being discriminated in your employment because you have a disability. So this means that if you do face discrimination in your employment and the discrimination is because of your cancer diagnosis, you can lodge a claim in the Fair Work Commission against your employer, either to have that discrimination cease, or if you're unable to work because of that discrimination, you can claim compensation for that. Now, discrimination can be direct or it can be indirect. Direct discrimination is when someone treats you differently to someone else because, for example, you've had to take more time off work because of your diagnosis. Direct discrimination could include things like demotion, not promoting someone, or terminating them because of their disability. Indirect discrimination is a little bit more difficult, a little bit more nuanced, and not as straightforward. It's essentially when a policy, rule, or a practice of an organisation that seemingly applies to everyone equally may have the unintended consequence of disadvantaging people with a disability. For example, if your employer didn't allow you to work from home because they had some broad policy that staff can't work from home, but if you could show it was reasonable and necessary for you to work from home because of your cancer diagnosis, this could amount to indirect discrimination. I like to often think of indirect discrimination just as a building not having an access ramp for someone in a wheelchair, something like that. Many people might not notice it, but if you're in a wheelchair and you can't get in, that's discrimination against someone who's in a wheelchair.